Well, good morning, friends. So, the topic of the day is recoveries under subrogation. Recoveries under subrogation. See, underwriters are able, by their rights of subrogation, to effect many recoveries in respect of claims for loss or damage to cargo insured by them from carriers and other bailees who may be primarily liable for such loss or damage to goods. In case of cargo claims, when there is any possibility of recovery from a third party, insurers will obtain a letter of subrogation from the claimant when settling the claim. Even otherwise, subrogation is a statutory right which is automatically vested in the underwriters on payment of the loss. But this letter of subrogation authorizes the insurers to institute proceedings to effect recovery in the name of the assured and at the expense of the insurers. So it's of vital importance to underwriters that prospects of recovery from third parties are actively pursued after a cargo claim is settled. Any recovery of a claim paid will go to reduce the claim ratio and thus directly benefit the cargo underwriter underwriting results. So to achieve this object, the recovery officials of the insurance organization should be well conversant with the laws relating to carriage of goods by sea, rail, road, air and the law governing multimodal transport operations. To establish a successful third-party recovery of a claim for loss or damage to cargo, it is necessary to show that the goods were in the care of the carrier or other bailees at the time loss or damage occurred. The goods were in sound condition with no packages missing when received by the carrier of the bailee. The carrier or other bailee failed to deliver the goods or delivered them at a damaged condition. So documents submitted with a claim in general supply the information necessary to establish the above. In principle, the person who has the custody of the goods is responsible for safe delivery to the next custodian. In the process, goods shipped conventionally pass through a chain of bailee before they reach the consignee. So parties involved may be professional packers, inland rail or road carriers, freight forwarders, warehousemen, port authority, stevedores, lightmen, custom authorities, clearing agents, and other at destination. So any of these parties may incur a liability while the goods are in his care. So the insurer will require proof of receipt and delivery of the goods by each party at each stage of transit in sound or damaged condition in order to establish as far as possible the stage at which the loss or damage occurred in order to pursue a subrogation rights of recovery after a claim is settled under a policy. So the Indian Carriage of Goods by Sea Act 1925 as amended provides thus this act was amended effective from 16th October 1992 and this provides that shipowners' responsibilities and liabilities are there to exercise due diligence and care to make the ship seaworthy, properly man, equip and supply the ship and to make the ship fit to carry the cargo, properly and carefully to load, handle, stow, carry, keep, care for any discharge the goods carried subject to the various immunities provided, and on demand and after the receipt of the goods to issue a bill of lading showing leading marks necessary for the identification of the cargo, number of package, pieces, quantity or weight as furnished in writing by the shipper, and the apparent order and conditions of the goods provided there is no obligation to show such details if the carrier suspect the accuracy or he has no reasonable means of checking. Such bill of lading shall be prima facie evidence of receipt by the carrier of the goods therein described, and the shipper shall be deemed to have guaranteed to the carrier the accuracy of marks, numbers, quantity, and weight of the goods as furnished by him. Otherwise, the shipper shall indemnify the carrier against all losses, damage, and expenses arising from inaccuracy in such particulars. Then, what are the shipowner's rights and immunities? Actually, the carrier shall be relieved from liability for loss or damage arising or resulting from unseaworthiness, unless caused by want of the due diligence on the part of the carrier to make the ship seaworthy, to secure that the ship is properly manned, equipped, and supplied, and to make the ship fit to carry the cargo. Thus, when loss or damage has resulted from unseaworthiness, the burden of proving the exercise of due diligence shall be on the carrier or other persons claiming exemption from liability. Neither the carrier nor the ship shall be responsible for loss or damage arising or resulting from negligent navigation or management of the ship, fire unless caused by the actual fault or privity of carrier, perils, dangers and accidents of the sea or other navigable waters, act of God, act of war, act of public enemies, arrest or reinstant of princes, rulers or people, or seizure under legal process, quarantine restrictions, act or omission of the shipper or his agent or representatives, strikes, lockouts, stoppage or restraint of labor, right and civil commotions, savings or attempting to save life or property at sea, inherent defect or vice of the goods, insufficiency of packing, insufficiency of inadequacy of marks, latent defects not discoverable by due diligence, any other cause arising without the actual fault or privity of the carrier or without the fault of or negligence of the agents or servants of the carrier, but the burden of proof shall be on the person claiming the benefit of this exception. So the carrier shall not be liable for any loss or damage resulting from any deviation in saving or attempting to save life or property at sea or any reasonable deviation. Then there is a notice of loss or damage. Unless notice of loss or damage be given in writing to the carrier at the port of discharge or at the time of removal of the goods into the custody of the persons entitled to delivery thereof under the contract of carriage, or by loss or damage be not apparent when within 3 days. Such removal shall be prima facie evidence of delivery by the carrier of the goods as described in the bill of lading. Such notice in writing need not be given if the state of the goods at the time of their receipt was the subject of joint survey or inspection. A time limit for legal action. The ocean carrier is discharged from all liability in respect of loss or damage unless suit is brought within 1 year after delivery of the goods or the date when the goods should have been delivered. So this act applies to goods, and goods are defined as including goods, wares, merchandise, containers, pallets, or similar articles of transport used to consolidate goods supplied by the shipper, and articles of every kind whatsoever except live animals and cargo, which by the contract of carriage is stated as being carried on deck and is so carried. So, monetary liability is there. When any consignment is entrusted to the railway administration without declaring its value, then the railway administration may restrict its liability for loss, damage, etc. to the goods if carriers to a particular amount based on the weight of the goods. So by notification, the government has limited the liability of the Railways Act to ₹50 per kilogram weight of the goods lost, damaged, etc. A higher limit of rupees 100 per kilogram is applicable to baggage only. This is bona fide booked luggage of a passenger. So carriage of goods by road is also there. Liability of road transporter is governed by the Carriers Act 1965, according to which anyone who carries goods not belonging to him for hire or reward is a common carrier. So the common carrier may limit his liability by a special contract if he chooses to do so. Otherwise, his liability is absolute as of an insurer of the goods. So the common carrier has only three immunities to escape liability, as against quite a number granted to railway under the Railway Act 1989. These immunities are act of God, states of enemies, inherent vice of goods, or consignor's fault. So the burden of proving negligence on the part of the carrier is not on the claimant, and it is the carrier who has to establish that there was no negligence on his part. Notice of loss, damage, etc. must be given to the carrier within 6 months from the date of knowledge of the loss. If the claim is not settled by the road carrier, suit must be filed within 3 months from the knowledge of loss as prescribed by the Limitation Act. Then there is carriage of goods by air. The Warsaw Convention of 1929, as amended at The Hague in 1955, is the international agreement governing the liability of air carrier in case of loss or damage to cargo and passengers' baggage carried from the country to another. This convention and the later Montreal version of the Warsaw Rules have been ratified by almost all countries of the world, including India. It governs all cases of international carriage by air. In India, for domestic flights, the liability of the air carrier is governed by the Indian Carriage of Goods by Air Act 1972. The liability of the air carrier is that the carrier is liable for loss or damage to cargo sustained during carriage by air, whether in an aircraft or an aerodrome, or in the event of forced landing anywhere else, so long as it was not due to cause such as inherent vice of the air cargo, defective packing by some person other than the carrier, his servants or agents, act of war or armed conflicts, act of public authority in connection with the entry, exit, or transit of cargo. The onus of proof that loss damage occurred while goods were not in an aircraft or aerodrome rests on the party alleging it. So the carrier is liable for damages occasioned by the delay of both baggage and cargo, but not if he can prove that he took all reasonable measures to avoid the damage or that it was impossible to take such measures. Then there is multimodal transportation. In India, the Multimodal Transportation of Goods Act 1993 was enacted on 2nd April 1993 and it came into force from the 16th October 1993. Broadly, the Act seeks to regulate the business of multimodal transportation and delineate the responsibilities and liabilities of the multimodal transport operators. And then liability of port authorities is also there. Major ports, the port trust established under an act of parliament is liable for loss or damage to the goods whilst they are in their care and custody. However, the cargo interests have to strictly comply with port formalities as per the regulations and bylaws framed by each port authority or port trust. So the port trust is liable for goods landed but subsequently missing, as well as for goods found damaged and for shortages if the packages in which there are shortages or damages had landed in a sound condition without any qualifying remark as per the port trust landing remarks certificate. Then postal authorities. Indian Post Office Act 1898 limits the liability of the Postal Authority to Rs 25 per package for loss, short delivery, delay, or damage unless the parcel is insured. Notice of claim must be given within 6 months from the booking date. Suit should be filed within 3 years from knowledge of loss, subject to 60 days notice under Section 80 of CPC. Then customs is also responsible, because under Section 27 of the Customs Act 1862, refund of duty is allowed for shortage due to pilferage and for goods lost or destroyed, or for shortened cargo or landed but missing cargo. So the application for refund should be made to the Assistant Controller of Customs within 6 months of the payment of duty. However, the limit for making such application in respect of personal effects of individuals and property of government, educational research, charitable institutions and hospitals is 1 year from the date of payment of duty. Salvage disposal is again important, because insurers are involved in disposal of salvage when a claim is settled on total loss basis and the insurers take over whatever remains of the subject matter insured. For the other circumstances where insurers are directly or indirectly involved in the disposal of salvage may be as follows. When a loss is assessed on a net basis after deducting the value of salvage, which is retained by the insured himself, in such cases utmost care should be taken to ensure that the value of salvage brought into account is reasonable. When the insured subject matter suffers irreparable damage and though not a total loss, it becomes necessary to dispose it off for the benefit of all concerned. When the damaged part of an insured machine becomes the property of the insurer when replaced by new parts. So this is all about the recoveries under subrogation, especially in marine insurance. Thank you very much.